Macmillan Audio presents Dobbs v. Jackson, recordings of the Supreme Court's decisions and dissents. In Dobbs v. Jackson Women's Health, Roe v. Wade, and Planned Parenthood v. Casey. Narrated for you by Ariel Blake and Imani Jade Powers. This program features an introduction from Faye Wattleton. Note to listeners: the legal documents you will hear have been abridged to assist clarity and understanding. For listeners interested in reviewing the full legal documents, please refer to the PDF that accompanies this audiobook.
I'm Faye Wattleton, and I'm a former president of Planned Parenthood Federation of America. It's been more than half a century since a series of decisions were handed down by the Supreme Court, recognizing the right to privacy and controlling women's reproduction. It meant protection from self-appointed intruders into the privacy of the bedrooms of married couples. It meant protection from meddling politicians and government enforcers. Women's most private decisions over how our bodies would be used would be made by women and their caregivers. These were watershed landmarks in the torturous struggle for reproductive safety and personal control. And it was important because pregnancy, after all, is not a benign, inconsequential condition. Women's bodies are not inert vessels. We are human beings deserving the dignity of making decisions for our lives. In the most recent data, we find that 700 women will die each year from pregnancy-related causes. It's estimated that 3 out of 5 could be prevented. Before pregnancy termination was legal, it was estimated that 9 times more lost their lives. So even in America today, which leads all developing nations in maternal mortality, women are still dying from pregnancy-related causes. So nearly 50 years later, and 60 million procedures, abortion is the safest and most commonly practiced surgical procedure in our country. Nevertheless, the right to make that decision to terminate a pregnancy has been relentlessly attacked, eroded, and now threatened to be extinguished through government enforcement. In what follows, you will hear the actual words from 3 Supreme Court decisions. The first, Roe v. Wade, established the bedrock of personal privacy and liberty from government-enforced reproduction. But sadly, the second 2 are a takedown of everything we hoped would be secure. Roe v. Wade was handed down in 1973, was based on the foundation found in Griswold v. Connecticut of the U.S. Constitution that it protected privacy as a matter of right for married couples. It was on that basis that the right to privacy in these intimate decisions was established and recognized by the court. The court framed pregnancy termination within the trimester structure of pregnancy. Ironically, it was the Nixon-appointed Harry Blackmun who wrote the decision for the majority, and Justice Blackmun wrote, quote, "This right of privacy, whether to be founded in the 14th Amendment concept of personal liberty and to restrictions as we feel it is, or in the 9th Amendment reservation of the rights to the people, is broad enough to encompass a woman's decision to terminate her pregnancy." This decision has largely stood, although a bit tattered, for almost 50 years. It's been relentlessly under attack by people who want to take it apart because they have not been able to overthrow it outright. Women have been maligned, and reproductive providers have sacrificed their lives in the service of women. 20 years after Roe v. Wade came Planned Parenthood of Southeastern Pennsylvania versus Casey, which was designed to impede the decision for women to straightforwardly request a pregnancy termination.
Sample complete. Ready to continue?